and welcome to the Y Channel. I'm Maddie Salamone. In this episode, we're going to be discussing the National Letter of Intent as we approach the February 2019 signing period. And we're also going to talk about 3 specific issues with the program itself and some things that you might not know about it. Before I do that, make sure you subscribe to the channel so that you don't miss any future episodes. And with that said, let's talk about the NLI. So what is the National Letter of Intent? Well, it is a binding agreement between a prospective college player and an institution. To give you a little bit of background on the National Letter of Intent program, this was something that was created in 1964, and it came into place as a protection for coaches because there was an issue at the time that other coaches were poaching players who had committed to a school and then they were leaving at the last minute. And so to address that, this program comes into place. And what it does is binds the player to a school for a year and also provides a guarantee that the school is going to provide financial aid of some sort to an athlete. Initially, it involved 7 conferences and 8 independent institutions. Today, it has grown to 657 institutions in Division I and II. It is a voluntary program, meaning that institutions are not required to participate and athletes are not required to sign in order to play at a school. When the NLI program was originally created, oversight for it fell under the individual conferences. And then in 1995, it sort of went to the SEC, who had oversight. And then in 2007, when the NCAA changed its headquarters to Indianapolis, where they pay $1 in rent, they took over the daily operations of the NLI program. Now, the language of the NLI reads that it is administered by the NCAA on behalf of the Collegiate Commissioners Association. And what you wouldn't know, though, by looking at the NLI site, is that the NLI is actually administered as an office within the NCAA Eligibility Center and is then technically governed by the CCA. Now, that sounds all well and good on the surface. The problem is that it really is a one-sided agreement because schools are not really bound by anything meaningful. All they really agree to in the NLI is that they will provide financial aid for 1 year. And they're required to provide the financial aid agreement along with the NLI. But even if there is a multi-year scholarship, which is now allowed in Division I, all they are promising is 1 year. So the NLI is basically a worthless document without the financial aid agreement that accompanies it. The difference between the NLI and the financial aid agreement is that the financial aid agreement carries no penalties whatsoever if the athlete ultimately decides not to enroll at the school. And in addition to that, there are things that will render the NLI null and void. What will render an NLI null and void is if the athlete is ultimately denied admission to the school, the athlete does not meet NCAA institutional or conference eligibility requirements, the athlete waits a year before enrolling, and the scholarship in its same amount is no longer available. But the NLI remains binding if the scholarship is available. So that leaves it up to the school to decide whether they're going to honor the agreement or not, but gives the athlete no such option. The sport is discontinued at the school, or there's some sort of recruiting rules violation. The result of an NLI being rendered null and void is that an athlete is no longer bound to the school and they are no longer subject to the penalty that they would otherwise incur. And they are also not allowed to sign another NLI in the same NLI signing year. That leads to the next major issue with the NLI, and that is that there are one-sided penalties. And what I mean by that is that short of there being a circumstance that renders the NLI null and void or invalid, an athlete is completely bound to the agreement to go to the school for 1 full year. And that gives the schools complete control to decide whether or not they will release an athlete from their agreement. While there are plenty of good actors within the NCAA and schools that will release their athletes simply because they want to be released, there are a large number that don't. If a school decides not to grant a release, then what that means for the athlete is that they must spend 1 full academic year in residence at the next NLI institution they attend, and they lose a whole year of eligibility. If a school breaches, there is no penalty. All that happens is that the athlete is released and not penalized. I think it's also interesting to note that while the year in residence requirement is very much characterized as a penalty in the NLI context, under the transfer rules, it's described as being something that promotes the academic interests of athletes. Now, if a school denies the request, an athlete has an option to appeal it. And it used to be that if they denied the request, it also meant an athlete could not be recruited by another school. That rule has changed along with the transfer rules that now allow athletes to transfer freely. So a school can't actually prevent someone from leaving, but the penalty is still in place. With that penalty in place, they can then appeal the decision. So they have to first receive a no-release decision from the institution. Then they have 30 days to submit an appeal online, and they can submit supporting documentation to the NLI committee. And then the school is allowed to respond with their own documentation. And then the committee renders a decision. So the appeals committee considers extenuating circumstances. And it explains on its website what those are. In general, the committee determines what constitutes extenuating circumstances on a case-by-case basis. However, examples may include illness of the student, illness or death of a parent, or financial hardship of the student's family which prevent the student from attending the signing institution. Again, the merits of each case are different, which is why extenuating circumstances are evaluated case by case. In the event that the first appeal is denied, an athlete has 30 more days to appeal that decision up to the NLI Appeals Committee, which is a separate committee from the first one. And this committee reviews all the information on its own, and then it will also then allow an athlete to have a teleconference call with the committee members, and then it renders its decision. But once that decision is rendered, that one is final. So if they deny the appeal, an athlete has no other option, and they are penalized if they do not attend the institution that they have now fought for so long. Here are the top 5 reasons from the 2016 to 2017 academic year for athletes requesting a release from their NLI. Coaching change, attending a different institution, financial hardship, academic reasons, and personal issues. Appeals are denied for all sorts of reasons, including a case very recently where an athlete wanted to get out of an NLI because when she was on a visit, she witnessed players in the locker room before a game doing shots and decided that that was not what she wanted to get out of her experience in going to college, and that she took her sport a little bit more seriously. Her request was denied and she lost a year of eligibility. It would also be denied in a case where a coach transfers. And that leads to point number 3. And that is that the NLI binds the players to the school, but the coach is not a factor in that at all. So if a coach leaves, the player is still bound to the school, even though when a player is making that decision, the coach is a huge factor in it because it determines all sorts of things like team dynamic and playing time and the type of people that a coach is going to recruit. And why should they be bound by that agreement when a coach can freely transfer and coach immediately? And they can do that in the middle of the season. It does not matter. And there have been cases where a coach will go so far as to keep a player coming to the school up until the day of the signing period. And upon an athlete signing, they've decided that they're going to another school. And the athlete is stuck, and there is nothing that they can do because they agree in signing the document that they are not bound to the coach and they are making the agreement with the school. All of these points make an NLI extremely unfair to an athlete and gives them virtually no benefit in return. So what is the NLI really? It is an agreement that binds players to rules that grossly favor the NCAA, conferences, institutions, and coaches, because the athlete at no point in time has any sort of bargaining power in the process, and they have very little influence on any of the rules that are created that affect them. So I will leave this one here. Please feel free to like, share, subscribe, and we'll see you back. All right, bye.
This video may constitute attorney advertising. The ideas expressed in this video by Maddie, as well as any posted comments, are opinions intended for informational and entertainment purposes only and should not be taken as legal advice. Receipt of this information, or using the YouTube platform or other social media platforms to contact the White Channel, does not create an attorney-client relationship.